rise, the Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Please have a seat, and we'll call file number 2025-0341, Energy Transfer LP et al. Versus the Honorable Judge James D. Gion, and sitting today are Justice Lisa Fair McEvers, Justice Jared Tufte, Justice John Jensen. I'll note that Justice Daniel Crothers has recused himself in this matter. Sitting in his place today is District Judge James Schachman. Welcome, Judge Schachman. And Justice Barr has also disqualified himself from this matter this afternoon, and sitting in his place is District Court Judge Stephanie Hayden. Welcome, Judge Hayden. Counsel, Mr. Hubbard, you represent the appellant, so whenever you're ready, you can take the podium. Feel free to adjust that podium to a height that's comfortable for you. There is a toggle switch on the right side. Thank you.
Mr. Chief Justice, and may it please the Court. Brad Hubbard for the Energy Transfer Petitioners. We're here today because back in February, Greenpeace International went to Amsterdam and asked a Dutch court to sit in judgment over this North Dakota lawsuit. Greenpeace seeks a Dutch declaration that this suit has been, quote, abusive, and that Energy Transfer's claims are, quote, manifestly unfounded. And it seeks damages that would offset any North Dakota judgment entered against it, effectively nullifying these proceedings and the jury's verdict. And that's why this court's intervention is needed. After more than 5 years of litigation, a Morton County jury spent 3 weeks evaluating the evidence and rendering a verdict. And the 9 jurors were unanimous. Greenpeace engaged in tortious interference, defamation, and conspiracy, causing tens of millions of dollars in damage. And rather than take responsibility for its misconduct, Greenpeace ran to Amsterdam seeking, quote, protection from this lawsuit, which it derides as a strategic lawsuit against public participation. Invoking the European Union's new anti-SLAPP directive, Greenpeace attacks, and this is in its Dutch complaint at paragraphs 57 to 67, North Dakota, the state's judiciary, the people of Morton County, and Judge Gion. And Greenpeace seeks this Dutch declaration that this North Dakota case is a slap under the EU directive for 2 reasons. First, it opens the door to Greenpeace recovering damages equal to any North Dakota judgment entered against it, in addition to its attorney's fees and costs that it incurred litigating this North Dakota case. And second, it'll preemptively block the recognition or enforcement of the eventual North Dakota judgment in any EU member state. So an injunction is necessary to prevent Greenpeace from attempting to nullify this North Dakota litigation. Everyone agrees that North Dakota's courts have the authority to enter anti-suit injunctions. As this court explained in the Federal Land Bank case, courts have the, quote, inherent power to protect their judgment and jurisdiction, the integrity of the court, and the orderly and expeditious administration of justice. That's 520 Northwest 2nd at 58. So the only question before this court is whether that power should be exercised here. And the answer to that question is yes, for the reasons underscored by the state in its amicus brief, the, quote, significant state interests in protecting North Dakota judicial proceedings from improper collateral attacks. And that's exactly what Greenpeace's Dutch suit is: an improper collateral attack, both in form and in effect. In its Dutch complaint, Greenpeace repeatedly asserts that Energy Transfer's North Dakota claims, the same claims that were tried to the jury, on which the jury found for Energy Transfer, are, quote, manifestly unfounded. And this is at paragraphs 5, 54, 57, 58, 66, 154, and 157 of the Dutch complaint. And that alone makes clear that Greenpeace plans to relitigate the same issues that were before the jury here. But Greenpeace's Dutch complaint goes further, repeatedly asserting that its, quote, sole involvement, in this case, was signing a letter. And that's in the Dutch complaint at paragraphs 3, 38, 155, 158, and 166. But that's not what the trial evidence showed, and it's not what the jury found.
Mr. Hubbard, if I could interrupt, one of the issues that's percolating for me is Greenpeace International has made some argument about our court not having personal jurisdiction over them. And Judge Gion did not address that argument. He noted it in his order that they raised it, but he didn't answer the question. But looking back, Judge Marquardt, who sat on this case earlier, did make a finding on that, or a holding on that, I should say, saying that there was personal jurisdiction over Greenpeace International. So I think it's been answered. But my question for you is, if the district court is wrong in saying there is personal jurisdiction over Greenpeace International, how does it affect, when this case has not yet been appealed, how does it affect your request for an injunction?
It doesn't, Your Honor. This court need not address the personal jurisdiction issues because that is not properly before it. As this court repeatedly has explained, personal jurisdiction issues are properly reviewable on an appeal from a final judgment. Go all the way back to 1930 in the Burek against Mann case at 231 Northwest 545, and again in Blue Arm against Volk at 254 Northwest 2nd 427. And this court has been equally clear that it won't exercise its supervisory jurisdiction where, as here, the proper remedy is an appeal after final judgment.
But your motion could also be appealed, could it not? Your underlying motion that the judge denied and that you're requesting us to supervise on is also appealable, is it not?
I believe it is, Your Honor, but it wasn't brought up in that posture. And my friends, again, part of what we are asking this court to do is to direct the district court, which has ruled on my friend's motion several times, both at the motion to dismiss stage and again at the 50A stage, right, at trial, and again on the 50B, right, did not change anything. And I'd submit, if Your Honor decide to address personal jurisdiction, Greenpeace is wrong on the merits. North Dakota has personal jurisdiction over Greenpeace, as the district court repeatedly found, including after a 3-week trial at which the parties presented extensive testimony and evidence, on the basis of which the jury found that Greenpeace International engaged in tortious interference, defamation, and conspiracy. And so, for an example of how this should play out procedurally, I'd point Your Honors to the Rodenberg case. This is at 632 Northwest 2nd at 407. And that's a case where initially there was a grant of a personal jurisdiction motion, dismissed one party, case got tried to a jury. On the appeal, there was a petition for a supervisory writ, but again, as this court has made clear, right, it won't exercise that jurisdiction when there's a remedy by appeal. And so the court, although it didn't grant the writ, it eventually reversed the personal jurisdiction issue on appeal from a final judgment, which is Greenpeace International's remedy here. It's to get the final judgment and then bring that up where it can sort of fully present the personal jurisdiction record to this court. And if it weren't clear that Greenpeace International's Dutch suit was a collateral attack, I'd like to point your honors to the remedies that Greenpeace seeks. It doesn't just want to block the European enforcement of the forthcoming North Dakota judgment. It wants offsetting damages to zero out any judgment against it in this case. And it also wants to force Energy Transfer to pay for the attorney's fees and costs it spent litigating this case. So even if this court were to affirm the judgment against Greenpeace, Greenpeace would still come out ahead. And so this court's intervention is needed to block the wasteful relitigation of the issues tried to and decided by the jury, to protect North Dakota's jurisdiction and ability to afford meaningful relief, and to defend the judiciary's integrity against an improper attack before a foreign tribunal. In the briefing, the parties discussed the approaches taken by the various federal courts. Before addressing those decisions, I'd like to just make two quick points. First, as your honors well know, none of those federal decisions is binding on this court. And unlike the federal courts, which are courts of limited jurisdiction, North Dakota's courts are courts of general jurisdiction. And second, any variation in the way the federal courts approach anti-suit injunctions is ultimately beside the point, because an injunction is required here under all of the approaches. There's simply no reason to countenance Greenpeace's collateral attack on the proceedings in this case, especially given that Greenpeace is using the Dutch action as an end run around North Dakota's appellate process instead of waiting for a final judgment and an appeal to this court. The federal cases generally analyze three factors in evaluating whether to grant an anti-suit injunction: whether the two cases overlap, whether there are equitable reasons to enjoin the foreign suit, and whether comity concerns nevertheless caution against an injunction. And analyzing those factors makes clear that an injunction is warranted here. Starting with the overlapping, this is a functional analysis that asks whether the parties and the claims are, quote, substantially similar. Here there's no dispute that the parties are identical, and I submit that there shouldn't be a dispute that the two cases present the same issues. Greenpeace alleges that Energy Transfer's North Dakota claims are, quote, manifestly unfounded, which requires relitigating the merits of those claims and claims on which the jury has already weighed in.
As I read the Dutch summons and complaint, maybe that's not the terminology they use, but they refer to both the federal and the state cases. The federal claims were dismissed, right?
Correct, Your Honor.
Could Greenpeace win in the Dutch court if they established only that the federal case was unfounded, but that the state claims were well-founded?
Perhaps they could, Your Honor. That two answers to that point. One, they're the master of their own complaint, and they can't sort of evade this prohibition on relitigating ongoing cases by adding other claims to their Dutch complaint, saying we can go forth with this whole thing. So if they want to replead their Dutch complaint to not raise issue with this state court proceeding, they're welcome to try that.
So could the district court here then issue a narrower injunction that enjoins Greenpeace International only from including the state claims in their Dutch complaint and leaves them free to assert only the federal court claim as a SLAP suit?
Yes, Your Honor. I don't think there would be a problem with that, although in looking at their complaint, it sort of strains credulity to suggest that it's not about this North Dakota suit, if you look at the damages model, where they've been harmed, what the harm is, they say that they, quote, want Energy Transfer to withdraw the state lawsuit, right, at paragraph 154. And I would suggest it may be an easier option for this court or the trial court to enjoin them from proceeding with the cases pleaded and invite them to seek leave of court if they want to submit an alternate complaint that sort of avoids the need for this court or Judge Gion to fly spec the current edition of the complaint, because again, they, as the plaintiffs in the Dutch action, are the masters of their own complaint.
Why should we assume the Dutch court won't honor the North Dakota judgment when it's finally entered?
Your Honor, I would hope that it would, but if you, the response that my friends on the other side filed with the Dutch court not only urged the court, they say that it is, quote, inconceivable. This is at paragraph 158 and 160 of their response to the Dutch court, which we submitted last night. And I apologize for the lateness of that. It says it's inconceivable that the North Dakota suit could result in a judgment that's recognizable and enforceable in the Netherlands. And that's regardless of what happens before a final judgment is entered or on appeal to this court. And so, and again, their complaint, they've gone there now, they're entire, if you sort of read that discussion, they urge that there is no way that this could be enforced. And if you look at, so I guess I want to pivot a little bit to the comedy point. And comedy is about mutual respect, right, across courts, across jurisdictions. And right, the general rule is that the second in time court defers to the first filed case. But not only do my friends oppose the recognition and enforcement of the eventual North Dakota judgment, they have also opposed a stay of the Dutch case pending resolution of this case, and that's part two and the parts where we highlight of their Dutch response. And so again, if we had true comedy across courts, here we would see the second in time court, the Dutch court, deferring to the first filed case. This court has made that point in Paulson against Meyer and in State against Sippel.net. And disregarding that norm has been a critical factor in the state court cases that grant anti-suit injunctions. I would point your honors to our petition at paragraph 42 and footnote 4, paragraph 45, 61, and 66, where we discuss Texas, Minnesota, and New York cases that all have a similar sort of temporal aspect and a failure of the second in time court to respect the first in time court. And more importantly, if your honors look at the EU directive, it is expressly anti-comedy. The chapter that Greenpeace invokes is entitled, quote, Protection Against Third Country Judgments. As discussed, in their opposition to our motion to dismiss and motion to stay in the Dutch court, they say there's no chance that the Netherlands courts should recognize or enforce this judgment. And of course, that seems inconsistent with their position in this court at 61 to 62 of their response, where they say that there is no reason the district court should have found the presumption that the second in time court will respect the judgment, that presumption has been rebutted. I want to sort of walk through quickly the equitable factors, sort of the prong 2 of the federal courts. Factor broadly assesses whether the foreign suit is an ordinary permissible parallel suit that should be allowed to proceed, or an impermissible challenge to or attack on the first suit. In this case, bears all of the indicia of an improper collateral attack. To point out 3 things. One is the timing. It's not a contemporaneous suit. They didn't bring the Dutch action until this North Dakota case had been pending for 5 years. And on the merits, the Dutch claims don't exist independent of Energy Transfer's North Dakota lawsuit. They're not saying that Energy Transfer's conduct in building the pipeline was somehow tortious. They're saying that bringing and maintaining and litigating this lawsuit was wrongful. And how are they going to prove that? They're going to show that our claims are manifestly unfounded, which requires relitigating the merits of those claims. And another way to look at it, if there were no North Dakota suit, there would be no claim for damages arising from the North Dakota suit. And if you look at the remedies, right, they want a damages award that offsets the eventual judgment against it in this case. I see I've got about 4 minutes remaining. Unless your honors have further questions, I have sort of one more point.
I have one more question, if that's all right. Paragraph 123 of the Greenpeace Dutch summons, I think is the title on it, it's page 29. Says, even if a case is partially founded, this does not rule out the possibility that it is a slap. So if I understand their briefing correctly, even if your client is right on the merits and the jury was right in its verdict, if your client has a bad motive for bringing those claims, that if the motive is in part to shut them up, then it doesn't matter whether the verdict was correct or not. Am I reading that differently than you are?
I think that's what it says. I'm not an expert in EU law by any stretch, but I sort of submit that the plain language of the EU directive in Greenpeace's Dutch complaint admits only one conclusion, that it is a collateral attack on the jury's verdict in the forthcoming final judgment. And if I'm wrong, I'm sure my friend on the other side will stand up and tell this court that, one, Greenpeace won't argue to the Dutch court that the North Dakota case is manifestly unfounded. Maybe they'll only argue a piece of that.
But I'm curious if it really is a collateral attack, even if it doesn't undermine the judgment, if the motive behind pursuing the lawsuit is bad under the EU law, then that's enough. That seems to be what they're arguing to the Dutch court.
But as I read, I guess that's not how I read their complaint, and there's some language that heads that way. It's a very long complaint. Again, I'm not an expert in Dutch law, but as I read their complaint, they're not seeking damages for part of the judgment or part of their attorney's fees based on this little piece of it. Same with so don't otherwise mention the federal RICO claim or the out of court statements. And if they want to replead in a way that doesn't involve relitigating the issues in this case, because I think the other thing you would like, that I would expect my friend on the other side to get up and say is that Greenpeace won't ask the Dutch court for damages that offset any judgment entered against it in the North Dakota court. Because I think even if their theory is a bad motive, what they're seeking to do is to, in effect, strip this court of jurisdiction, strip this court of the ability to render a meaningful judgment by seeking an entirely offsetting judgment in the Dutch court.
If we have questions about Dutch law, are we stuck with what the expert witnesses have said in the record in this case, or is that something that we can look at English translations of Dutch law and try to figure out for ourselves?
I wouldn't think there would be any problem looking at an official English translation of Dutch law. It's something that would be judicially noticeable, like the statutes of the United States or of any other jurisdiction. And so Greenpeace's Dutch suit is an improper collateral attack on the proceedings. In this case, the jury's verdict in the state's judiciary. Energy Transfer respectfully requests this court direct the district court to enjoin Greenpeace from pursuing its Dutch action further.
I have a question since you have time left.
Of course.
I didn't want to take your time, but you mentioned the Attorney General's office, the brief that they filed. And they don't take sides. They're clear about that. I want to ask you, what is the test that you want us to apply? The district court applied the strict test, if I'm understanding things correctly. Are you arguing for the lax or the liberal test, or are you arguing for some other test? The BAE Systems case talks about a third test. What are you actually asking for? What test?
Your Honor, I don't think it matters what test you all adopt, and I would submit, if you're going to choose among them, I would encourage your honors to choose the lax one, not because of what happens sort of in prong one about are they the same, or not because of what happens in prong two about the equity, but really where the cleavage in the cases appears to be are the impact of comedy. And the federal cases that take that narrow approach, a lot of them rely on the Federal Anti-Injunction Act. Right? This is Section 2283 of the U.S. Code. It's a congressional limit on federal courts' power to enjoin state proceedings. And they say, well, if we, courts of limited jurisdiction, are limited in this way, we should also consider a similar limitation as to foreign jurisdictions where this court and these North Dakota courts do not have a similar limitation.
Mr. Hubbard, thank you for your initial argument. You do have time reserved for rebuttal. Ms. Ellsbury, whenever you're ready, you can take the podium. Again, feel free to adjust that podium to a height that's comfortable for you.
May it please the court, counsel. My name is Betsy Ellsbury, and I am here on behalf of Greenpeace International. After listening to Energy Transfer's initial arguments, it has been made clear that there are three aspects of this case that are essential for this court to remember. The first boils down to three words that I did not hear come out of Mr. Hubbard's mouth: abuse of discretion. The standard of review is abuse of discretion. Judge Gion did not abuse his discretion 3 times. He did not abuse his discretion when he determined that the issues being litigated in the Dutch action are not the same as the issues that were litigated here in North Dakota. He did not abuse his discretion when he determined that the Dutch action failed to prejudice any of those equitable considerations in the North Dakota action. And he did not abuse his discretion when he noted that if comity were to apply, the conservative approach argues for a denial of the anti-suit injunction. The second thing I ask this court to remember is what the Dutch summons says and what it does not say. The Dutch summons does not refer to the North Dakota jury verdict. The Dutch summons does not refer to the forthcoming North Dakota judgment. The Dutch summons does not seek to overturn the forthcoming North Dakota judgment. And the Dutch summons certainly does not seek to prevent enforcement of the forthcoming North Dakota judgment. All it does is pursue claims available to my client under Dutch law.
In in American law, in the 30 jurisdictions or so that have anti-SLAPP statutes, normally we refer to that as expedited motions to dismiss, stays of burdensome discovery, early exit for defendants that are being mistreated by the process. This seems to be different. Your client filed this years after the suit was initiated. Is that the right label for what this Dutch statute is, or does that mislead us in some way?
That it's an anti-SLAPP, Judge?
Right.
The European Union directive at issue does pertain directly to anti-SLAPP causes, but the underlying issue is the fact that my client over in the Netherlands is not relying on that exclusively. The underlying issue is that it is our position that Energy Transfer committed torts against my client under Dutch law. The fact that the European Union directive supports those positions, that a tort was committed, is there for that reason. But even without that European Union directive, it's our position that torts were committed under Dutch law.
But torts are alleged to have been committed there that couldn't have been brought here as a counterclaim of some type.
Justice McDevers, none of them could have been brought here in North Dakota. The first cause of action over in the Netherlands is our position that Energy Transfer committed a tort under Dutch law when it published statements that my client is part of an enterprise which incited, funded, and facilitated crimes and acts of terrorism, and that it employed a pattern of criminal activity. My client is based in the Netherlands. Energy Transfer is based in Texas. That statement could not have been litigated in North Dakota. The second cause of action is the fact that it is our position that under Dutch law, Energy Transfer's pursuit of the federal RICO action constituted a tort under Dutch law. And as Justice Tufte was asking opposing counsel, it goes to their reasons for pursuing it, their intent to silence. And it was just that third cause of action that is being brought over in the Netherlands that pertains to the North Dakota action, only in the sense that it is our position that Energy Transfer's pursuit of this state court action constitutes a tort under Dutch law. Now, opposing counsel continually refers to this manifestly unfounded, but what he is ignoring is the fact that under that European Union directive, it's manifestly unfounded or abuse of court proceedings. Under that EU directive, as Justice Tufte noted, even if a case is partially founded, that does not rule out the possibility of a slap. Abusive is explained at our unrefuted expert's affidavit, specifically Professor Barthet, where he said, it's abusive by considering whether it is likely to result in the prevention, restriction, or penalization of public participation, whether it exploits an imbalance of power between the parties, and whether or not it pursues unfounded claims.
Ms. Salisbury, how does that differentiate from the First Amendment argument you made in your 12B motion?
Can you ask that question again?
The public participation factor, or suppressing public participation. Basically, you made an argument, First Amendment, freedom of speech argument in your 12B motion. How is that different, the argument versus public participation and what you're able to say and what you cannot say? How's that differentiated from the United States First Amendment? That was argued, right?
Thank you, Justice Schachman. And yes, and it is different because one of the questions under this European directive is if it was brought to silence my client. And so it goes, if it's more restrictive than that First Amendment. And I would note that this is both, this applies to both the second and the third issue over in the Netherlands, both Energy Transfer's actions when they brought the federal RICO suit and the state claim, and that part of the analysis over in the Dutch court will be whether the state and federal actions were brought to silence international, and that is different from any First Amendment claim. Before I get into the merits of this case, I wanted to follow up on one of Justice McEver's questions to opposing counsel, where she asked why this matter wasn't appealed. And the answer was simply that it was not. And I would remind this court that for this court to exercise a supervisory writ, it either needs to find that the relief requested affects the fundamental interests of a litigant or presents matters of important public interest, neither of which are present in the matter before this court. In addition to that, before I get into the merits of this matter, there has been a lot of discussion by opposing counsel of this Article 16 of the European Union Directive. And I would remind this court that Article 16 only pertains to recognition of a judgment. We don't even have a judgment in North Dakota yet. Article 16 provides that member states shall ensure that the recognition and enforcement of a third country judgment in court proceedings against public participation by a legal person domiciled in the member state is refused if those proceedings are considered manifestly unfound or abusive under the laws of the member state. Again, that is not yet relevant. When it would become relevant is if after there is a judgment, Energy Transfer attempts to enforce that judgment against my client over in the Netherlands. Now, while Energy Transfer would like this court to believe that this is some absurd law that a foreign country wouldn't recognize a North Dakota judgment, I would remind this court that this great state of ours has the exact same statute. NDCC 2820.3-03 provides that foreign judgments do not need to be recognized if, quote, the specific proceedings in the foreign court leading to the judgment was not compatible with the requirements of due process of law. That is all Article 16, which is not yet at issue, is requiring. In addition to that, we have federal law along these exact same lines. The Speech Act at 28 U.S.C. 4104A1 provides that U.S. citizens, quote, against whom a foreign judgment is entered on a basis of speech to bring action have declared repugnant to the Constitution or the laws of the United States are therefore enforceable in our country. There's one more thing I want to touch on before I want to get to the merits of the matter, and that was Justice Tufte's question to opposing counsel something along the lines of, if this court finds that an anti-suit injunction is warranted just as it pertains to that third claim over in the Netherlands, could it be issued? And I would argue that it could not. They did not make any in the alternative argument. Their argument to the district court was that the Dutch proceedings should be stayed until completion of the North Dakota action. I would also note for this court that that exact same argument is being made in the Dutch proceedings, and that they are asking the Dutch court to stay the Dutch proceedings until final judgment is entered here in North Dakota. As opposing counsel noted, as for the issue of an anti-suit injunction, it is a three-step process. The gatekeeping requirement of are the parties in the issue is the same. The second question of would the foreign litigation, how would it affect the forum court based on the equitable factors? And the third question of do the principles of comity affect the consideration? When Judge Gion analyzed this same parties, same issues concept, he properly held that the issues were not the same. I would urge this court to remember that it is Judge Gion who listened to the North Dakota claims for 3 weeks. He determined that they are not the same as those being brought forth in the Dutch court. Judge Gion held, quote, North Dakota does not recognize a SLAPP or anti-SLAPP action as such. So as that issue was not raised in North Dakota, but is alleged and recognized in the Netherlands, there is a difference on that issue. Likewise, the North Dakota action did not consider any allegations of the defamatory statements directed toward International from Energy Transfer. He added all of the defamatory claims in the North Dakota action addressed those from the Greenpeace defendants towards Energy Transfer. Now, Energy Transfer argues that the North Dakota action is dispositive of the Dutch case, and that is simply not accurate. The Dutch action does not hinge on the North Dakota case being meritless. As noted in our unrefuted expert's testimony, Professor Barthet, he stated that a court of an EU member state is not required to consider whether it is probable that the claim would succeed, which is unlike some U.S. anti-SLAPP statutes. He also noted, and Recital 29 of that EU directive provides that claims made in abusive court proceedings against public participants can be either fully or partially unfounded. Further, Dr. Hermans, our second unrefuted expert testimony, or affiant, stated that a possible granting by the Dutch Court of International's claim against Energy Transfer does not require a finding that the North Dakota judgment was incorrect. Dr. Hermans testified, both decisions can exist independently of one another. So with that, it's clear that the North Dakota case is not dispositive of that Dutch action, and what's actually going on is that my client is seeking remedies available to it in its home court jurisdiction that were not available in North Dakota. More specifically, the Dutch action hinges on Dutch law that will not be resolved by the forthcoming judgment. And several different circuit courts have analyzed very, very similar fact patterns, most notably the 8th Circuit in Goss, where that court held that it refused to enter an injunction that would, quote, prevent a party from seeking a remedy solely available in the foreign jurisdiction. Those are the facts in the case before this court. In addition to that, the Canon Latin case out of the 11th Circuit, in that case, the motion for anti-suit injunction was denied, where it would bar a claim that, quote, hinges on a statutory right that was unique to Costa Rica and that could not have been resolved by a judgment of the domestic court. It's the exact same facts in the case before this court.
Is the Dutch remedy or the claim similar to an abusive process kind of a claim that your client might bring here? Sort of a, not exactly malicious prosecution, that would be more of a criminal matter, but you're abusing the civil legal system in order to harm my client with frivolous or foundless claims? It
could be along those same lines, Your Honor, but I would note that would only, I mean, not the same, but I guess the same concept, but I would note, but that would only pertain to the third cause of action, We still have the first cause of action where Energy Transfer called my clients criminals and terrorists. We still have the second cause of action where it's our position that their actions in pursuing the federal RICO court case was a tort under Dutch law.
The first one sounds like defamation to me.
And it's my understanding that under Dutch law, it's just a tort in general, and they don't have specific types of torts, but yes, that would be my understanding as well.
That's not solely available in a Dutch court, it's also available here.
Not in North Dakota, though, however, Justice Tufte, because my client is based in the Netherlands, Energy Transfer is based in Texas. And so that, I cannot conceive how North Dakota would ever have jurisdiction over that claim. If the gatekeeping threshold is passed, and again, Judge Gion correctly found that Energy Transfer did not pass that gatekeeping inquiry, then the court gets into the equitable factors, with the three most prominent, I would say, being a threat to jurisdiction, a threat to the forum court's public policy, and this concept that the second action is vexatious. And I believe that Attorney Hubbard, in his arguments that my client is attempting to nullify the North Dakota judgment, or that my client is trying to offset it, I believe his arguments fall within these equitable factors. As far as his position on the nullification, I would note that, again, the Dutch summons doesn't even reference the forthcoming North Dakota judgment. It doesn't even reference the jury verdict. In fact, it was issued in February of 2025, so before trial in this case even started. So even if it were to attempt to zero out the damages, it would not be a threat to this court's jurisdiction or public policy, as that was similarly argued in Goss, and that court held that where a foreign remedy would effectively nullify the remedy a party legitimately procured in the United States, while that may be objectionable, it is not a threat to U.S. jurisdiction or any current policy. And I would again note that along those same lines, Dr. Herman in his affidavit stated that even if the Dutch court were to classify the North Dakota State Court as a SLAP and consider its initiation unlawful, that would not relieve International of the obligation to comply with any judgment that may be rendered against it by the North Dakota State Court. And I would note that Justice Tufte asked Attorney Hubbard the question of, does this court have the ability to go do its own research essentially and find other European law scholars, and while I don't think this court is prevented from doing so, I would note that Energy Transfer had the same opportunity as my client did to put that information before the district court and to put that information before this court, and it chose not to.
It just seems unusual to me to rely on expert witnesses to offer us interpretive arguments about the application of laws. That's usually the lawyer's job, not the expert's job. Is that a common practice in your experience? Well,
all I can say about that is I think because it is a foreign law that most, if not all of us in this courtroom are not familiar with, in addition to the fact that sometimes there are those translation issues when something is being translated from one court to another. I think it was just the easiest and the best way for my client to get that information before Judge Gion, as well as this court. And again, I would note that it was not refuted. They had the opportunity to obtain their own experts to counter what our experts said, and they chose not to. Attorney Hubbard also...
Excuse me, was there an objection to the use of your expert?
To the best of my recollection, I am very confident that there was no objection, Judge. Attorney Hubbard also argues that the Dutch action is a collateral attack on the forthcoming North Dakota judgment. A collateral attack, in the simplest form, seeks to undo what has been done. It has been made very clear to this court that that is not what's going on over in the Netherlands. In the Netherlands, my client is seeking relief available to it in its home court under Dutch law. I would also like to touch on Justice McEver's question to opposing counsel about personal jurisdiction. And Justice McEvers, you are correct in that Judge Marquardt, before trial, before Judge Gion was on the case, issued an order stating that the court had personal jurisdiction over my client. But I would say that that was almost like at the prima facie stage, in the sense that in the Ensign case, this court held that even if the plaintiff survives a dismissal by alleging facts that might establish personal jurisdiction, and that is what was going on in Judge Marquardt's order, plaintiff, quote, still bears the burden of proof on the issue of personal jurisdiction and must establish by a preponderance of the evidence at trial or when the court holds an evidentiary hearing that personal jurisdiction has been established.
So we don't have a ruling from Judge Gion.
So, I'm sorry, Judge, you're correct. We still do not have a ruling from Judge Gion on that issue. And so not only would common sense tell us, but also in the Gallo Winery case, a court may only issue an anti-suit injunction over a party subject to its jurisdiction. And so, not that I have heard any reasons today why this court would find that Judge Gion abused his discretion in denying Energy Transfer's motion for an anti-suit injunction. If this court was inclined to do just that, it would first have to find that personal jurisdiction has been established over my client, which it has not.
Does that limit us as well if there's been no finding of personal jurisdiction and it hasn't been appealed? Does that also apply to us?
I believe
in the supervision?
I believe it does, Your Honor, in the sense that I'm not sure how this court could issue an order preventing my client from seeking action in a foreign court if the court has not, may I briefly conclude?
Briefly.
Established personal jurisdiction over my client. Thank you.
Thank you. Mr. Hubbard, you have 6 minutes remaining for rebuttal.
Thank you, Your Honors. A few quick points. First, I want to talk about what I didn't hear. I didn't hear any dispute that the North Dakota courts have the power to enter an anti-suit injunction. Didn't hear that the federal cases are somehow binding on the North Dakota courts. I didn't hear that they won't argue that this case was manifestly unfounded before the Dutch court, and they haven't agreed that they won't seek offsetting damages. Now, we can talk about what hypothetically they may seek under the Dutch law, but I think what's before Your Honors now is the complaint that they have filed, and that complaint makes clear it wants to nullify the judgment. Looking at what is the proper interpretation of the EU directive, I'd point Your Honors to Article 4.3, where it suggests that there is a conjunctive definition to abusive court proceeding against public policy. It's not brought to genuinely assert a right and pursues unfounded claims. Second, Your Honor, our view is that Judge Gion abused his discretion when he determined that the issues are not the same across the two courts, and it's a question of law, and it's black letter law, that an error of law is an abuse of discretion. On personal jurisdiction, they raised the issue in their 50A, and Judge Gion rejected it. That's at docket 5193, the transcript at pages 77 to 78.
Mr. Hubbard, just to be clear, so you agree with the framework that the district court used, you just don't agree with how they applied it?
Yes, Your Honor, we don't have any dispute about the broad framework. We don't think that framework binds this court, right? This court is a framework that other courts look at. To the extent Your Honors find that persuasive, that's a framework you can look at. I think we satisfy all of the factors that are required. In particular, the only real delta in the federal case is about the importance of comedy, and they're just this EU statute, as Justice Tufte pointed out, is sort of the opposite of a comedy statute. It's an anti-comedy statute that is all about not recognizing foreign judicial decisions. And Justice Tufte, you are exactly right about the EU statute. It is significantly different than every other EU statute that any other anti-SLAPP statute that anyone has looked at. That is because it is procedural, it is substantive. It provides a substantive right to collect damages based on a SLAPP suit somewhere else, as opposed to the anti-SLAPP statutes in the 30 or so U.S. states that have adopted them, which provide procedural mechanisms to require more proof at the motion to dismiss stage.
Those states that have slap back provisions, though, isn't that more analogous to what this provision is in the Dutch court?
It could be, Your Honor, but again, those tend to be limited to cases brought in that jurisdiction, and there is sort of the other piece of this right that involves the Dutch courts reaching out and saying, look, this is a statute that we're going to apply with respect to foreign judgments, and not recognizing those foreign judgments and allowing you to recover damages for them. And the damages request is important because one of the things this court has the power to do is to protect its own jurisdiction, to provide meaningful relief. And if they end up with a perfectly offsetting damages award for having brought this suit, that is not, I don't think by any definition, meaningful relief. Three more quick points. One, Goss, the Circuit decision. I invite Your Honors to look at page 368. There, the court makes clear that its ruling is not based on the merits of the injunction at all, but on the fact that there's no longer a live controversy before it because the defendant had paid the U.S. judgment. And so I'm not sure how that cuts against this. If they want to pay the judgment here, we invite that.
Mr. Hubbard, I'm going to interrupt you. Your opposing counsel indicates you haven't argued how the district court abuses discretion. I found the word abuse once in your brief. Where in your brief is your argument about abuse of discretion? Under which characterization of abuse of discretion are you saying the court erred?
It is an error of law.
Error of law.
And it was the determination on the same issues prong. We think that is a legal conclusion, and to the extent that Judge Gion, who has done phenomenal work in this very large, very long case, believed that these cases didn't present the same issues because one had an anti-SLAPP statute and another didn't, that is an improper application of that legal standard, because what the legal standard looks to is the functional analysis. And so what you go through is what do they need to prove? And what they need to prove is that our underlying claims in this case were manifestly unfounded. And how do they prove that? They retry those same claims. Final point on personal jurisdiction, we're not asking Your Honors to act as against Greenpeace International directly. We're asking you to direct the district court to enjoin them, and the district court has found repeatedly that it has personal jurisdiction over them.
Mr. Hubbard, thank you for your initial argument as well as your rebuttal this afternoon. Ms. Ellsbury, thank you for your argument this afternoon. This case will be taken under advisement, as all cases are. This court will be adjourned.